I just might begin with some opening comments, if that's okay, folks. So welcome everybody to the Yarra Drug and Health Forum July meeting and forum, and it's titled Courting Drugs, Punishment or Opportunity, and we're really pleased to have such three diverse and challenging speakers, as I hope. And before we start, it is NAIDOC Week, and the theme of NAIDOC Week this year is healing country and thinking about the whole of Australia, both physically, spiritually, community-wise, socially and individually. And I think the theme of healing is really apt at this time in our nation's history. And with that in mind, I'd like to acknowledge that I'm on Wurundjeri land, people of Kulin Nation, and I'd like to pay my respects to elders both past and present. I'd especially like to pay my respects to Uncle Colin Hunter, who is a Wurundjeri elder, and pay our respects to any Aboriginal or Torres Strait Islander people that are in the meeting today. We acknowledge the contribution, the history, the amazing gifts that Aboriginal culture and the Aboriginal community has been shared with the wider community, and we look forward to a day when treaty reconciliation, constitutional recognition truly occurs in this country for the stolen nature of the land and for the harm that we have done collectively and individually to Aboriginal and Torres Strait Islander community across this country. So we do pay our respects and acknowledgements. And I'm sure you'll be acknowledging the traditional owners of the land, no matter where you are during this meeting. Elisa is a dynamic and amazingly intelligent and gifted person within this community. And she represents the new leadership of our sectors in the area of justice and in the area of drug and alcohol, mental health and community engagement. And Elisa currently is the executive CEO of Flat Out, which is a fantastically independent organisation. Elisa also serves on the Adult Parole Board, a new invitee into that role, and she has had a strong history in therapeutic jurisprudence around the Family Drug Court and originally the drug court out of Dandenong. So welcome, Elisa. But she's also from Tasmania, which does make her an interesting soul. So welcome, Elisa. It's great to have you.
Thanks, Pete. Thanks very much for that well-rounded introduction as well. I'm glad to, have the Tasmanian influence emphasised right at the very end. But otherwise, you've been far too generous. I'm not sure, except perhaps for the dynamic bit. I'll see what I can do in terms of pulling rabbits out of my hat in the next 20 minutes or so. Thank you very much for having me and your invitation to speak to you all. I'm kind of glad that it's a smaller group today, despite the bigger audience that we might see access the recording later on. And I hope that you do mainly to hear my colleagues coming up. But I think it's a tricky topic, this one. There's all sorts of pros, cons, and everything in between. Opportunities, as it says, as the title suggests, dilemmas and challenges. But before I begin in that space, I also want to acknowledge the traditional custodians of the lands on which we're all meeting. On my lands, that's Wurundjeri country. I want to pay my respects to elders past, present and emerging, to any Aboriginal and Torres Strait Islander people listening in today, to celebrate NAIDOC Week, and also to particularly acknowledge, especially in the context of this conversation, the shameful and ever-growing numbers of Aboriginal and Torres Strait Islander people caught up in our prison and our justice system more broadly. It's an indictment on Australia as a whole, and I certainly want to acknowledge the pain and the anguish and the suffering that's caused by an inherently racist justice system. So today, I wanted to talk about particularly courts and drugs, and it's fitting for me because that's where I've spent my entire, at least the last 15 years, if not more, both in Tassie and Palawa country and in Victoria. When I traversed the strait by plane, it wasn't actually that difficult, but traversed the strait to come over to manage the drug court. But before I did that, I was involved in the court mandated diversion program, which is Tasmania's version of the drug court. And the reason that I wanted to get into that space is pertinent to today's topic, I think, because I came out as a brand new social worker and I was working in the youth health space at the Link Youth Health Service in Hobart, which was the biggest youth health service in the state and certainly in the south of the state. And I was the National Illicit Drug Strategy worker. So I helped to run the needle syringe program down there and provide counselling and support to the young people that were accessing the service. And almost all of them, because of the illegal nature of their drug use, had some involvement already with the justice system, but keeping in mind that we were working with people as young as 12 all the way through to 25 years of age. And almost without fail, we had every single one of the people that walked through the doors of our open access space or our needle syringe program had come into contact with either the police or in a more formal way in the court system. And when the court mandated diversion program was set up in Tasmania, one of the things that struck me was that there wasn't a whole lot going on for them, and that this provided one clear shout out to the recognition that drug use is fundamentally and always a health issue, not a legal one, certainly not a criminal legal one. So I wanted to be involved in that very, very thorny and very crunchy nexus point between justice and health, particularly in between alcohol and other drug use and justice. And that led me over here to Victoria. Now, what I thought I would do today is give you a really quick, for those of you who, and I'm looking at the attendees, but also keeping in mind the people that might be accessing this afterwards, a quick overview of the sorts of available options that we have in Victoria for the ways in which people will through their engagement with drugs, particularly illicit substances, as prescribed in various acts in this state and nationally, and the way that they might interact with the court system, both pre-sentence and post-sentence. And of course, we have a range of ways in which the courts are used or have attempted to intervene mostly under the guise of supporting people to get out of the justice system by using the mechanisms of the court to be able to support people to put behind their illicit substance use, which of course is an intriguing juxtaposition, because what we know, and I was recounting to a colleague of mine only last Friday, a story of a young person at the Link Youth Health Service who'd walked into our open access service as a 16-year-old. He, at that time, was already using on the methadone maintenance program down in Tassie. Also prescribed benzodiazepines, and also used alcohol to excess. And on Christmas Day, I'd met him 3 days after Christmas Day. On Christmas Day, he'd used all of those things in quick succession and again to excess, put his 6-month-old child in the back of his car and driven the wrong way down a major highway in Hobart. Unfortunately, there was an older woman driving up the right side of the road, and they collided. Now, this young man, he was he wasn't injured, nor was his no worries, Jane. Nice to see you. He wasn't injured, neither was his young child, but unfortunately, the woman driving the other car died. And so he was coming in. the justice system didn't know what to do with him. His final sentencing was delayed for 18 months. In that 18 months, he was on bail, and there were all sorts of programs that were thrown at him to try and support him in holding his anxiety. But of course, the only thing that was going to hold his anxiety in that 18 months, where he didn't know where he was going or what he was going to do, he hadn't even remembered committing the act. He turned to self-medication, and his drug use got worse and worse and worse. It spiraled out of control, and so eventually he did 8 years in the adult jurisdiction in Tasmania. And I saw him only 3 years ago on a recent trip back home, and I watched him running, working the younger people around him, running drugs to different people in the morgue. And I remember thinking that at every single point we could have intervened, but it wasn't going to be the court that did that. And in fact, it was the very justice system that had been set up to protract the uncertainty that young man felt at the time, an anxiety that I could never imagine to experience. We let him down, and the justice system let him down. And so one of the things that I, when in working in on the other end of the system in the drug court, of course, we have pre-sentencing KISP, the Court Integrated Services Program. We have the ARC list, which is pre-sentence, which is focused on mental health, but of course, inevitably involves high levels of navigating substance use as well, and how they interact. We've got diversion programs both at police level and at the courts, at the bail level. We have restorative justice programs set up in community justice centres like the Neighbourhood Justice Centre, which you'd all be very familiar with. And then at the post-sentence end, where people, but for a drug treatment order, would be doing prison time up to 2 years by virtue of the fact that they are in the drug court and on a drug treatment order, because their offending had a demonstrable link to their drug use. Then we enter a space of monitoring and accountability that would otherwise not be applied in any other context, in a court setting or in a justice setting. And one of those mechanisms that people are required to undergo throughout the 2 years, up to 2 years of their drug treatment order, both in the magistrate's court and now also in the county court, is drug testing 3 times a week, supervised, where you are required to strip down to your ankles and up to your armpits and provide a urine sample in front of a nurse 3 times a week. And then that sample is analysed, sent to a laboratory, and an immunoassay conducted. And if it comes back to show that there might be, that you might have used substances in the preceding life cycle window, then the number of times that you do that might result in you doing a short time in prison. And that's curious, because in any other context in the justice system, mere use of a drug would not necessarily send you into prison. Nick, it is very degrading, and I describe it explicitly because this is the sort of activity procedure that you sign up to when you sign up to something like a drug treatment order. Now, I'm not suggesting for a second that a drug treatment order doesn't have its place. And the reason I say that is because, as I mentioned before, were it not for drug court, the people that are on a drug treatment order now in Victoria would absolutely be in prison serving out sentences. And I think that is absolutely on the scale of responses a bridge too far. But I think also that, going to your point earlier, Peter, about championing lived experience, I think one of the things that we need to do better with any response, be it court-based or otherwise, while ever we have a legal framework, a criminal legal framework around the use of drugs and illicit substances, defining what is illicit and not, while ever we have that, we really need to look to the people for whom these sorts of programs and mechanisms are set up to support, ostensibly. We need to make sure that we're involving them at every step of the way, so that we're not perpetuating stigma, so that we're in as best a way as we possibly can, given that unfortunately whenever court and justice come into play, stigma is one of those things lurking very closely around the corner. But we do need to be able to bring people in, and we have to be able to critically reflect, all of us, on what our policies and procedures and processes, those degrading ones that, as you so beautifully put it, Nick, what purpose do they serve? I know that there is suggestion at the moment put forward by some political mechanisms that everybody on bail should be drug tested. What purpose would that serve for somebody, full stop? In fact, especially when drug testing is such a nuanced science, it's such a specific science, and any toxicologist will tell you that it's not a perfect science either. It depends on so many variables of each individual, and even more broadly. What purpose does it serve to put people through that sort of degrading procedure? And when you talk about it in a pre-sentence context, you're also targeting people who haven't been convicted of anything yet, and may not have even pleaded guilty to something, and so certainly are deserving of the presumption of innocence. And even if they weren't, what does that say to about us as a society if we're not critically reflecting on at every step of the way, without it becoming just a given that to be on a drug treatment order, for example, or to be found to have a demonstrable link between your offending behaviour and your substance use would somehow necessitate you going through such invasive procedures 3 times a week. I'm not suggesting that it's wrong, but what I am suggesting is that as soon as we start to accept that as just a given, the way that things should be, then we necessarily take away from the people for which these programs are set up for, ostensibly in the first place. Those are my reflections on courts and drugs. I think I'm on time. Is that right?
Yes, you've got about 3 or 4 more minutes if you want to add. But while you've got that, Elisa, what would you say to the issue of so much treatment, AOD and mental health treatment, now being wrapped up within a justice framework?
I think it's extremely problematic. As a nothing, that's kind of a nothing comment, isn't it? I think the reason why I think that that's problematic is because the justice system should never be used as a way for health and social supports to abrogate their responsibility, for a start. Secondly, the justice system was never set up as a all things to all people. Now, certainly I've seen the way in which I think that it can work very well is where in the context of drug courts, for example, the authority of the court is used not only and even not particularly for the person for whom on the drug treatment order to be held account, but for the service system around it to be held account, and used as a mechanism to say, I have 30 people or 40 people on my support load. There is no possible way that I'm going to be able to give you the intensity of service and support that you require. The court can then say, well, why not? And what do we need to do? How do we need to put pressure on which points to be able to provide that service? But I think that in that way, courts can be useful interventions to bolster a service system and as an advocacy mechanism for making sure that health and social service providers are able to step up, and that they're receiving the resourcing and supports to be able to do so. But when we start using them as a an alternative or another mechanism to provide treatment services, it was never their intended purpose in the first place. And so it becomes so then people who are already subject to extreme amounts of stigma and judgment from the general population, from the community more broadly, have then an added layer of justice involvement, of criminalisation, which is extremely problematic and even more difficult to overcome than the stigma that they were already facing through their mental health challenges or their drug use.
It's also now, I would like to introduce our second speaker, Mr. Daniel Clements. Now, Daniel has a checkered history of work. He was a professional musician that toured the world, playing drums, I think. Is that right, Daniel?
That sounds about on the mark, yes.
Right, so we all have stories about drummers.
We all have stories, don't we, Peter?
And rock bands, so we won't go there. But Daniel is the general manager of all the justice and justice innovation programs at Jesuit Social Services, and has been in this role for probably over a decade. Is that right, Daniel?
That's about right.
How long have you been with the Jesuits?
Just over 10 years.
Yeah, so congratulations on your decade up.
Thank
Maybe
you.
with good behaviour, they'll release you soon. But and Daniel's worked in employment and education programs with Mission Australia in the past in South Australia. He's a person of great values and passion towards fairness and equity, especially for those that end up in the justice system. And so it's with great pleasure that we welcome Daniel today. And Daniel's going to give us an overview. One of the things he's going to do is talk to us about how the Jesuits have really championed innovation in the justice area. So over to you, Daniel, and thank you for being here today.
Thanks, Peter, for that very warm introduction. I'm not going to give you the detail of expertise that Elisa was able to provide you with, but I hope I can provide you with a bit of an insight and overview of our work in this area and why we think value diversion so highly. But firstly, too, I would like to also acknowledge the traditional owners of the land that we meet on. I'm on Wiradjuri country and acknowledge the people of the Kulin Nation and pay my respects to elders past, present and future. And as Elisa did, I too want to note with shame the overrepresentation of Aboriginal and Torres Strait Islander people in the criminal justice system. At June 30 last year, there were 30% of people incarcerated nationwide were Aboriginal or Torres Strait Islander. And the harms of the prison system clearly disproportionately impact on First Nations people. And we see that in our work at Jesuit Social Services on a daily basis, where we know the over-incarceration flows from a history of colonisation and dispossession, systemic racism, intergenerational trauma and discriminatory laws and practices. And nowhere was this more starkly illustrated than by the estimated 474 deaths in custody over the past 30 years since the findings of the Royal Commission into Aboriginal Deaths in Custody were handed down on April 15th, 1991. So in this presentation, I'm going to focus more on young people and children and the work we do in that space. But first off, just at Jesuit Social Services, we are a values-based, a social change organisation. We have, our vision is around building a just society, and we have three core values around welcoming, forming and discerning and courageous. These are the values that shape who we are and how we operate across our programs. If our CEO was here with us today, she would say we do and we influence. And I'm going to talk a bit about that area of justice and crime prevention. That is the area that Peter in his introduction spoke to, that I have a responsibility for here in Victoria. Just a little bit about our justice programs. So there's a suite of programs that we deliver here in Victoria, and fair to say that at every point in the continuum of intersection with the criminal justice system, we think there are opportunities, just as Elisa identified, to engage and support individuals, children, families and young people to swim away from the criminal justice system. Now, Navigator is a program for 12 to 17-year-old children who are disengaged from education. And fair to say that for us is a really considerable, serious risk factor when we're thinking about diversion that we know we need to be attentive to. But whether that be children through to the men and women that we see on our programs exiting out of prison after having cycled through the criminal justice system over many years, again, as with that example of the young man that Elisa spoke to, we see multiple missed opportunities to actually support individuals and families and the children and communities more broadly to actually be diverted away from the criminal justice system. But our approach across the programs is fundamentally relational, it's restorative, it's family-focused, strength-based. We pay attention to culture. We partner with Aboriginal community-controlled organisations to strengthen our approach in those areas, working with Koori kids and families, and our approach is trauma-informed. So when we think about substance misuse, and that is not uncommon, as we'll see with the individuals' children that we work with, we think about people who've experienced trauma and the steps they take to self-medicate. I guess the other thing that we're going to talk about, or what I'm going to talk to, is diversion is an opportunity to keep people in community. And while I think I also probably need to preface the fact that Victoria generally has a pretty good record, or certainly in the past. I think we might have lost the plot a little bit in recent times. But there has been a focus on diversion and in supporting that to be legislated so that it plays out in our courts. But if we compare and contrast with what's happening in America, where they're closing down prisons and transforming them into libraries or community gardens, and they're in Republican states, I think we've got a way to go. That's briefly, I'm not going to read it out. They're some of the things that I think I'm going to try and touch on here and open up for conversation. Just so we're clear, I've got a definition of diversion up there, but fundamentally, as I think I indicated, we see diversion as an opportunity to support people to swim away from the criminal justice system. We know that touch with the criminal justice system is highly risky. You know, people who are incarcerated are generally 50% more likely to return to custody than those who aren't. And those numbers are even higher for young people. So at every point, as early as possible, we strongly believe in an approach that prioritises an opportunity to engage with children and support them to actually make better decisions and understand the impact of their offending. Again, I'm not going to go through this very busy next slide, but I think it is incumbent on us to remember who we're dealing with and the characteristics of the children that we see in the justice system. And I think I highlighted a couple there in bold. This information's from the Youth Parole Board. They report every year. They do a snapshot. And I think this is traumatic reading, really. You know, 70% of the kids that we lock up in either of the two youth justice precincts experience trauma or neglect. They've been suspended or expelled from school. They present with mental health issues. These are some of the most vulnerable and traumatised children in our state, and we then subject them to incarceration. So fundamentally, there's something going wrong there. Again, I'm just going to touch on this. We piloted a diversion program for a couple of years in 2016-17, which, together with the President of the Children's Court, then President, and Judge Peter Cousins, we developed a program that was really, again, about supporting kids. It's now been rolled out statewide and now part of our justice system and enshrined in legislation. But when we think about diversion, we always think about what are the risk factors for individuals, and again, thinking about children, young people here, and what are some of the protective factors. And when we were piloting that program, there were kind of three key areas that we took into account. One was the dynamics around family and what support might be needed there. The other one was education. And as I said, that disengagement from education, from school, is a huge risk factor. And we see that when 70% of the kids that we lock up have been suspended or expelled. And the third one is that intersect and touch with the criminal justice system. So In many ways, diversion at this point is too late, but they are some red flags for us, which are really a call to act. And we'll talk about police obviously have some discretion in relation to cautioning, formal cautioning, but we should be engaging and intervening earlier. But the risk factors and protective factors help us sort of make decisions about where what sort of touch do we need, and what does it informs the assessment and the work that we then do. So here's one pretty obvious reason why we should consider diversion. Most notably, it is the amount of money that it costs to incarcerate people. So as that stat says, $2,500 a day for a young person in detention versus $300 a day on a community-based order. Again, it's just a red flag for us to think about what are the steps that we could be doing to support that child or young person in community as opposed to incarceration. What people forget is that everyone gets out. So it's just a question of time. And on average, the amount of time that young people spend in custody is a relatively short period of time. So we see incarceration as an absolutely last resort. However, what we do need to be doing for those that we do incarcerate, we have to be focused on rehabilitation and on a therapeutic response to that trauma. Not much better in the adult justice system. As we know, incarceration is really about, punishment, rehabilitation and sending a message to community. We're pretty good at the punishment side of things, but we are not good at rehabilitation. We're not good at supporting people to understand the impact of their offending and the impact on community. Prisons in that adult space, just our view is that prisons are traumatic environments. They separate people from families, from home, from communities, and the networks of relationships that hold them. Our reliance on imprisonment as a response to crime is harmful, ineffective, costly, and discriminatory. Diversion, on the other hand, offers us an opportunity to use these resources and address some of the causes of offending. We fundamentally believe in diversionary programs because A, it lowers the risk of reoffending, and B, it makes communities safer. So we know the importance of social connection, of economic participation, of access to a job, access to good health, and providing young people with a voice. Diversion is responsive to these factors, and the support it offers is responsive to the needs of the individual. So again, I'm making sort of grandiose statements here about the principles of the work, but in our view is that, again, that opportunity to build a relationship, to build trust, to understand what's happening for the young person is much more effective than that step into the criminal justice system, into the court, which are generally kind of scary places. And then we use diversion because, and here we use restorative practice fundamentally as a way of doing justice that shifts the power back to communities, and it holds people and young people that we work with to account in meaningful ways. Plus, it supports them to address their behaviour. So group conferencing, which is legislated under the 2005 Children's Act, seeks to respond to the harm with healing, with benefits for victims, offenders and the wider community. And in a nutshell, this approach is really about developing a shared understanding, but also a shared accountability. And often our focus is on, the focus of broader, community is around punishment. But unless we actually support somebody to understand the impact of their offending, it's unlikely that they're going to change those behaviours. So together, we don't think restorative practice is a panacea or a silver bullet, but together with purposeful, intentional case management, therapeutic support, clinical support, we think we can put the pieces of the puzzle together that will actually support young people to change behaviours. But probably from a Jesuit social services perspective, the most important thing that we need to think about in diversion is really around how we interrupt cycles of persistent and entrenched disadvantage. So we focus on these young people, we focus on the pathways through the courts and through the criminal justice system, whereas in fact what we need to do is focus on communities of disadvantage. So we see, and we would prefer to look at, decarceration, which it demands significant changes in legislation and policy as well as a mindset. But the sort of legislative reform would look at repealing some of the regressive measures that see too many people denied bail or sentenced or imprisoned for minor offences and precluded from community sentencing options. So we certainly would want to see an end to mandatory sentence and the prohibited and stopping harmful measures such as solitary confinement. That does terrible damage. I always think I have 4 kids and I cannot imagine what it would be like as a parent to not be able to respond to them in needs. And throughout their, time growing up, yet we think it's okay for 13, 14, 15-year-olds to be locked in small little, really awful, best-of-block little rooms with nobody there to respond to them at their time of need. So fundamentally, we also believe it is appalling that we lock up young children. So we strongly believe that we need to raise the age of criminal responsibility to at least 14. And that would at least then give us an opportunity to begin to really work from a therapeutic sort of response rather than a punitive response. All these resources will be available, by the way, and you can check out our website. As I said, that influencing arm of Jesuit Social Services is always very strong, and we've put out a number of papers on that. In relation to diversion in Victoria, again, Elisa would be better to speak to than me, but our view of this is obviously there's within that court space, there's pre-court, pre-plea, post-plea, and different sort of components falling within that. I'll be really honest, I don't think it's... schools often remind me of courts sometimes. You've got these judges, magistrates with who really kind of sometimes shape the culture of those environments. And it's not an even playing field. So if you're a Koori kid who's picked up in Mildura and have to attend court there, you just won't get option to the same, you don't have the option of the same opportunities that you do if you attend the Melbourne Children's Court. So we think that, there are some good offerings, and I've named some of them there, but really we need to ensure that we have legislation in place for consistency so that young people, so it's not a question of luck about where you turn up. The next slide is, again, just essentially saying the same thing in a different way, but basically, as you can see, along that kind of continuum for kids, there are opportunities to intervene. And again, we strongly believe once we get to the criminal justice system, we're late in the piece. We should have been doing there would have been red flags, and we should have been acting on them much earlier. But that said, within that justice continuum, there are obviously a range of options. And as I said, I don't want to be too hard on the Victorian criminal justice system because, in some ways, there are some areas that we've led the way. But I do think it's incumbent on us to keep a lens to this because there's more work that needs to be done. I'm not an academic, so in relation to does it work, I think the evidence suggests that any time you engage relationally with a young person or a child or an individual or a family, you're more likely to get better outcomes. I always encourage people to, step into the children's court and have a look at that and imagine what that's like when you have those characteristics they don't define you, because we without fail see kids who are incredibly resilient. But the courts are not, pleasant settings. I think, they're not conducive to actually understanding what's actually happening, particularly if you have lower level cognitive functioning. So does it work? Well, we strongly certainly do believe that it does. I was having a look at some, just kind of Googling around to see what was out there. And I like this sort of Annie Casey Foundation quote around, It's more effective for juvenile courts and probation agencies to issue a warning and stay out of the way. And I agree. I think sometimes, clearly there's a role for statutory services to play, but I think not so much as staying out of the way, but bring in the providers who can actually really offer assistance and make a difference and bring those resources to bear. I'm doing how am I going to a couple of minutes. So what's challenging? Look, I think we need to name the fact that systemic and structural racism plays out. We see that, we know that we work closely and in partnership with Victoria Police, and they do some fantastic work, but I think we need to acknowledge that there are, somewhere around 80% of the kids that we lock up in this state come from non-English speaking backgrounds. There's something going wrong there. And again, that's a challenge for us to actually think about what we might do there. As I said, there is inconsistency in relation to what diversion looks like, and more needs to be done in that area. To sum up, look, every child and young person should have access to the opportunities in life that enable them to flourish, to complete their education, to get a job, to have somewhere safe, stable and affordable to live. Diversion offers us a way to tailor our support to the needs of kids, young people and families, and build awareness around that impact, help them break those patterns, but also use the tax that we all pay much more effectively. And my last slide there is just some of the artwork that was done by kids from the Larrakia Nation who participate in our group conferencing program, not because they had to, but because they wanted to say sorry to the victims of their offending, and they wanted to produce some art to do that.
Daniel, that was sensational, and a lot of material there. I've got one question for you before we go to Nick, and here's the question. In what you've learned over the decade that you've been involved with, particularly in this justice area, do you think there is an appetite within the community for justice that would lead to integration and acceptance and welcoming? Or is our justice system really another word for let's punish the buggers?
Two things. I think there is an appetite in community if you provide education. Without fail, if we have the opportunity to engage in dialogue, where we're open to learning and open to listening, and again, the voice of young people, they're not shy telling you what they think, So if you provide them with a space to give a view, they will provide that. And I think that is the most powerful of tools for changing hearts and minds in many ways. In relation to the justice system, I am eternally optimistic, and I do see, I think if you can do it in America, if you can do it in states that vote for Donald Trump, surely there's an opportunity for us to do something here and to do something differently.
Thank you, Daniel. It's also, remember, questions for the end, and keep them in mind, put them in the chat room. It's with great pleasure that I welcome Nicholas Thomson. Nick, welcome. Nick's got a extensive and varied career. He's an epidemiologist by training, also a podiatrist by training. And Nick has spent much of his life's work in places other than Australia. And so he brings an international perspective to this topic. So international that the reason we asked Nick to speak was because of a project in Frankston, which is about as international as you can get in lockdown. And some might say Frankston is a different country, where Nick, in combination with many key stakeholders, local government, police, treatment providers, and people with lived experience, got together, and the Department of DHHS, to really try and design a program to intervene earlier and prevent people getting into the justice system that were committing and involved in crime related to drug use. So that's one of the reasons I got Nick along to speak today. So welcome, Nick, and we look forward to your presentation.
Thanks so much, Peter, and thanks so much to Nick Wallace and the team of the Yarra Drug and Health Forum more generally, and also to the previous colleagues here, Elisa and Daniel, for really interesting thoughts. Just before I go on, I acknowledge Peter's comments about having a kind of a varied background, and so varied, in fact, that I decided to drive over to Victoria from South Australia just as the borders were or were not opening. So I came from Ghana country and now find myself on Bunwurrung and Bunurong country down here on the peninsula for a couple of days, and so want to acknowledge those people and their country and their elders past, present, and indeed emerging, and share the perspectives and comments from everyone here, I'm sure, but certainly our speakers today on the overarching drivers of Indigenous rights violations and the role that colonisation and indeed over incarceration, over criminalisation has in those rights being persistently violated, and it's a horrendous situation that we all continue to need to grapple with on a really daily and personal basis. So just to say that and bring that to bear, and also, being in the fortunate position of heading up to the Northern Territory in a few weeks for a 6-month stint up there, and a former Masters of Public Health student of mine doing a PhD now in criminology in University of Flinders will be up there at the same time, and she's looking at this concept of jealousing, which is a really interesting Indigenous concept, and a kind of this interplay between what happens when you actually come out of prison and go back to your Indigenous community and the kind of the dynamics there. And it's, these kind of stories that many people obviously have no idea about. But understanding these kind of interplays, and seeing how we can use these kind of learnings to roll back the 90+% of people who are incarcerated in the Northern Territory who are in fact Indigenous, which makes the national average of 30% seem, it must be very limited numbers in other states, but what's happening in the Northern Territory is obviously a national emergency. So just to kind of lay that out there. But I just wanted to pick up on Elisa's really great phrase around the thorny intersection of justice and health, and I would take it a little bit further as well. And the stuff that kind of brought me to where I am with a lot of stuff that I do these days is the even thornier intersection, perhaps, Elisa, of these kind of things in Southeast Asia. And I call it, the intersection of police injustice, health, and rights. And considering we're talking about courts and the role of courts and drug courts, I thought it was kind of interesting that, my real first lesson in this was the extrajudicial killing of 2,500 people that used drugs in Thailand in 2003 under the leadership of Prime Minister at the time, Thaksin Shinawatra. So the fact that they completely bypassed the courts kind of made it really apparent to me that if we really wanted to make a difference, we would also have to bypass the courts and look at what we could do in the front of space there and in the prevention of incarceration, the prevention of arrest in the first place. So I'll come back to that in a little bit as we go on. But just to kind of speak to topic, which is what Peter had asked me to do, and reflect on our project called the PACER Plus project that we introduced in 2018-19 down in Frankston. Now, many people here in the audience will know the PACER model, of paired up policing and mental health workers responding to secondary responses to an event which appeared to have an alcohol and drug element to it, and that the idea behind PACER was that people could access or would be accessed with critical mental health support in the kind of very instances that things were happening in terms of a police call out. So we took that model and we added another element to it, which was that's why it was called PACER Plus. And the trial was to pair up people with lived experience, who we called AOD peer workers, with police, with the Frankston Police, having access to the Frankston Police Station, and paired up and then would go out in secondary call-outs where safety was deemed to be okay, but the issue was really a critical alcohol and drug issue. The offending was likely alcohol and drug related, and there was an opportunity where we thought where the principle of the program was, where there was an opportunity to engage the person, the person who was, in the spotlight for the offending, engage them in treatment and related service pathways, which perhaps they hadn't had options for before, or maybe it had been disconnected from. And so this was a piece of work that was done with Peninsula Health and Victoria Police, actually, and in a really detailed workup in terms of the design. Well, detailed at the time, we thought so. But then, the objectives was to trial, what could we do by embedding peer workers, in police responses? Could we improve access to alcohol and drug services and pathways for early intervention? And ultimately to kind of drive this idea of alternative policing models that really build on the idea of the partnerships between law enforcement and health more generally, and to see whether we could add something into that space in the Victorian setting, outside of what we already knew was happening, whether that was PACER, or whether that was the kind of the ongoing advocacy work that was being done between police and service providers and others, of course, in Victoria, in terms of the context of the needle syringe programs in Melbourne and Victoria more generally. And there's a long history there of police engagement in that, and many advocates who are here today in the audience being involved in brokering those discussions with police in an ongoing way, right? And there continues, and you don't have to look very far down many places in Melbourne at the moment to know that work needs to continue to go on, because despite what we know is whether it's a injecting drug facility or there's people who are accessing services who are then walking the streets afterwards, we do know that interactions between police and people that use drugs are incredibly common. And in fact, if you take this to a kind of a different discussion around in a more more kind of philosophical perspective, there's not many people that the police actively seek to interact with. I mean, they don't actively seek to interact with someone who may commit a burglary, but they do actively seek to interact with people who may use drugs. And I think it's an extraordinary perspective that well, in many countries you're rewarded for those kind of interactions, and you can tick some boxes and click off that you've got 30 people in the last month, but you're actively looking for them, and I just think that's an indictment. So part of our objective was to look at what could be changed, what would improve referral pathways, what would improve access to treatment and other services, and what would decrease offending. And that was the kind of the premises of the program. So this program set out to be a year-long pilot program. It took 3 or 4 months to get organised and to get operationally ticked off, both by Peninsula Health and police. And I'm only telling you this in terms of the efforts that have to go in to advancing a kind of a trial like this. We then had it up and running for 2.5 months exactly, at which point we had 60 call-outs that involved the peer worker and the police. And at that point, at 2.5 months into the actual operationalisation of the trial, when we've still got 4 or 5 months to go, the trial was abruptly stopped. And it was stopped not because it was unsuccessful. In fact, on the contrary, it was stopped because the Victorian Police Union people had raised issues of safety with them, that the police had felt unsafe, that they were having to go driving with people that had lived experience of drug use, and how this was really compromising their ability to crash red lights with sirens, and et cetera, et cetera. So you started to see the operational and cultural interplay of how policing sees itself. Not everyone within that, and not everyone within the jurisdiction of Frankston, but it only takes one or two people to raise an issue with the police union, and you've got a problem on your hands. Ironically, when we finished the evaluation and the report, 18 months after we'd started, 58 of the 60 people who had been reached hadn't reoffended during that time, which is, it's a strong result. It would have been nicer to have, 200 or 300 reports to kind of verify that, but it certainly looked like it was a program that had great promise. So just to say it worked was really good, but just in terms of some more detail around how and why it worked, it seemed to provide opportunities. It definitely provided opportunities to engage people in treatment who were treatment naive, people who had not been part of the treatment system before. For whatever reason, they hadn't been reached before, they weren't engaged with programs in the catchment for a whole range of reasons. And having someone with lived experience really navigating and negotiating the discussions in the moment really, it showed that 58 of these people out of the 60 actually engaged in service. So it was excellent. The time it took them to engage in the service required 2 or 3 follow-up visits. At this point, because it was still a police matter until the police decided it wasn't, they would have to attend, and this created problems for the police in terms of the use of their time. They didn't really feel they needed to be there after the second or third time, which we didn't disagree with. But just to kind of say that was one of the things that they didn't particularly enjoy, even though it was working for the AOD peer workers, who at this point were right in their element. They're out there rocking up to a scene with the cops, and then really having a role, and then having follow up with this person over the next 2 or 3 weeks, and working them and advocating them into service provision, which appeared to be a good thing. The communication strategy internally between Peninsula Health and Victoria Police wasn't as good as it needed to be. If we reflect on this, and the reason I say that is that people responsible for the programs at Peninsula Health were distant to what was happening on the ground. Likewise, the people at Frankston Police Station were often posted elsewhere. The leadership of the program sat with someone in Somerville. People would clock in and clock out. There's a lot of movement within policing, as you all know, and certainly within departments of health and departments of justice, indeed. And so a lot of people coming in, the idea of handover on a pilot program didn't go as well as it needed to. So there was ways that the program was undermined, but not deliberately. Undermined through lack of awareness, really, and so that was a problem as well. The safety issue I spoke to, and one of the we had people with lived experience actually using their own cars as part of the go out to the scene. Police didn't like that. Again, we don't necessarily disagree, but that was the way everyone had signed off on the program. So I think if we would do it again, the police could go out in their own cars with the AOD peer worker. If the Yarra Drug and Health Forum is around stigma and lived experience, several of the peer workers really felt discriminated against by a percentage of their policing partners and colleagues. The term druggie, junkie, why would I want to go at that, da-da-da-da-da-da. It wasn't the overarching experience, but it was enough it's discrimination and stigma any way you look at it. So it's offensive and it was difficult. But for the majority of people, this wasn't an issue. But what we did find was that if we changed the name from peer workers to alcohol and drug experts, the perception completely changed. on behalf of the police. Now, the peer workers themselves felt a little bit uncomfortable, even though they were alcohol and drug experts, in many and varied ways. They didn't feel that the term expert sat well with them, even though it sat better with the police. And I mean, that's something to look at a different time. But the consumers, the clients, the participants, the offenders, whatever you want to call them, had enormous, affiliation with these people right in the moment. The investigation of the incidents went so much better. People were talked down. People were calmed down. The AOD peer workers obviously have unique experiences and abilities that many other people do not have in terms of relating to people in crisis, especially where there is an alcohol and other drugs. And it was actually so obviously successful that the police, when we were speaking to people when we were reviewing the program, were saying, listen, this does work. We are already talking about whether we could expand this to our domestic violence programs and also our road traffic programs as well, in terms of the context of accessing people at different points in drug use and different interactions with the justice system and their drug use. So there's this kind of a reasonable amount of forward momentum that we thought could be picked up going forward. Now, it hasn't happened. We've been invited to brief senior policing executive on the findings of the program, but Lawyer X and a few other things come along, and senior police are hard to find at particular times. So for a variety of reasons, we haven't had the opportunity to take these issues further. And despite that, and knowing that, and I'm sure many people agree, it's not difficult to find senior police that will say on the record, whether it's former commissioners or whatever, that you can't arrest your way out of drugs, and that fantastically cliched comment. But actually getting them to sit down and look at how that might operationally work is we think is a more difficult discussion. But rather than see pilots like the PACER Plus program remain as pilots, we would argue that they be expanded, and we really can kind of take these things a lot further. There's a couple of things that we think would be useful kind of reminders here, and one is around leadership and the development of protocols. Now, if policing works to protocol, if departments of health work to protocol, then the protocols have to be rigorous enough that there is no kind of room for to fall back to something that is default. And so we think there's work that we thought with a little bit of extra work, the protocol stuff could have been sorted out relatively quickly. And we still do so think that. And so bottom line was it worked, it went well, but we haven't had the audience to kind of push it forward, but we would be very happy to work with anyone who wants to do that. A couple of broader kind of reflections on this, as just because on the 3-minute mark there, thanks, Peter. A lot of the ideals that I got into for the diversion stuff came from that setting in Southeast Asia where the extrajudicial nature of policing is much more kind of apparent. But some of the drivers for engaging in the advocacy work in Asia around this stuff is really around what is going on with these various systems. How do you get the police to work out that, geez, wouldn't life be better if we weren't arresting so many people? Or wouldn't the prisons be a little bit easier to manage a tuberculosis outbreak if there wasn't so many people in the prison? And so trying to get probation and policing and corrections and the courts on the hook in terms of just reducing the number of people in the system, we could get that. But the way that you do that is it's diversion before arrest, and that's where the PACER Plus model was going as well. So yes, I've sent the evaluation. Just to answer the question from Christine, I've sent the evaluation to the YDHF people, so that can be sent out. No problems. You can contact me. Just a couple of really take-home points here. I've got to say there has been historical resistance in my experience to looking at the issue of diversion outside of what is already kind of official diversion and court diversion at the between Youth Justice, Department of Justice and Department of Health. And I think the whole dynamics between those agencies, there's some tension around this stuff, but I don't know why, but I think it should be broken down. And the other thing that I think is important here is that, back to Elisa's point as well, what I found with the PACER Plus model was it was client engaged rather than court mandated. And I think if we really go back and are really serious about prevention of detrimental and harmful drug and alcohol issues and also harmful offending, then we really need to kind of go back further to that, which leads us to how do we set up our agencies? How do we set them up to collaborate rather than to compete? And it's this idea that there's a lot more that we could do to build trust between police and communities. And this to me seems like a really logical and easy win. Happy to talk about any of that, Peter, but I'll leave it there at the moment.
Yeah, thanks, Nick. That was a great summary. And the question that I have for you, just before we go into general questions, is diversion has been with us for a long time. And diversion, for most people would know this, is discretionary. So police don't have to divert people if they deem it unacceptable or unwarranted or too much of a risk. Why is diversion not embedded as a principle that you go to first rather than seen as an option if you want to consider it at the point of interaction between the police and the general community?
Yeah, listen, Peter, I mean, it's a great point. The thing that I would say quickly to that, and there's a former student of mine from Victoria Police with something that we can't share yet, but we'll try and get it released. She looked at this exact thing, the idea of discretion around the implementation of diversion. And she interviewed police at middle to senior levels within Victoria Police around this. And it became really obvious that the practice of discretion in the context of diversion was itself inherently biased, driven by personal biases. And and I think, this is exactly the kind of things that we need to get into in terms of discussions. I mean, if you've got a diversion program, it shouldn't be it shouldn't be implemented with bias.
Yep. No, so thanks, Nick. So I'm encouraging people to put questions in the chat room. So, Nick, do you have any questions in there? I couldn't see any. Nick Wallace?
I haven't seen any questions come through. There were, because I was moderating some things as well, there were things that came up, but I'll have to scratch my brain for a moment to remember. So if anybody does have any questions, feel free to either jump in or drop them into
we've got
our question there.
Yeah. So a question I have to all the panellists, and so Daniel, Elisa and Nick Thomson, is this. Do you really think that the community understands the harm that is done by putting so many resources? So this is a loaded question, into a custodial system as opposed to a system that sees its role as getting people back into society or not taking people out of society and making it able for them to live in society in a pro-socially and acceptable way. Do you see the point of my question? Like it seems to me in Scandinavian countries, I know that the moment a person goes into prison, they are planning for them to leave that prison and they're thinking about getting them out as quickly as possible. We seem to have a different mindset in this country. So just your comments on that. Any of you jump in.
Can I just say very quickly on that? I mean, I think that Scandinavian systems are a very good example, Peter, of systems where there is a really significant investment in therapeutic response and rehabilitation. We don't see that commensurate response in Australia. I do think that people have no real insight around the costs of the justice system. And that I'm talking about from policing through to somebody coming out after having spent 20, 30 years cycling in and out of prison on short stints because of picking up drug charges or breaching bail or all those sort of areas. So, but I do think, as I think I indicated earlier, if you provide people with good evidence and opportunities, I think the Sentencing Advisory Council do this fabulous, work. I don't know if it's still there, or, be the judge for the day sort of thing. That sort of is a really effective way of shifting attitudes and understandings and bringing people around.
I think it still is there, Daniel, but not many people get a chance to see it. It's a bit like programs on Radio National. Great programs, but no one listens to them because they don't know they're there. So, Elisa or Nick, would you like to comment?
Yeah, I mean, I think Daniel, you're absolutely right. That the Sentencing Advisory Council work is brilliant to illustrate that point. And I have done one of those programs in a bunch of a wide range of people, some from the more conservative end of the spectrum and everybody in between. I was obviously on the other end. But what I found was that we were all in furious agreement and certainly more lenient than what ultimately the sentencing judge gave on the particular case that they used to illustrate that point. I think with your original question, your question, Peter, about whether or not people are engaged enough to understand or are informed enough, have access to the information readily enough, reminds me of what's happening in the ACT at the moment with an Attorney General who's from the Greens, who's just pushed through a rise in the age of criminal responsibility for young people from 10 to 14. And Shane Rattenbury's his name, and he was on ABC Breakfast one morning last week as he was announcing his win. And one of the questions that was put to him was, do you think that people, the ordinary public, would be okay if they really thought about a 10-year-old going to prison? And he said, of course not. But the problem is that people just don't understand that that's the reality, because it's not a sensational story that's on the front page of the major newspapers. It's not what's leading in the headlines of particularly in this pandemic focused world. And so I think to your, just to back up your point, Daniel, about access to information, to informed and perhaps less apathetic approaches to this community. To this particular issue. I think we don't have enough information available, and the information that we do have is for the academics and for the echo chambers, and not necessarily distributed to the broader public.
Nick Thomson, any comment?
Yeah. A couple. I'll go more broadly before focusing back into Melbourne. But just recently, I'm not sure many people know what's happening in Myanmar at the moment. We're actually collecting data in Kachin State in northern Myanmar, which has a really heavy availability of heroin and a really high prevalence of use. It's also, fundamentally Baptist. It's been, unchallenged for 30, 40 years. And the whole idea of community detox run with the evidence of the Bible as the kind of way that it goes forward, and also kind of meting out kind of different forms of punishment, whether that be use of shackles or violence, et cetera, et cetera. And so some of the stuff that's come out over just recently over the last kind of few weeks is that even the people that have been advocating really heavily for this approach, which is the community, have started to see the damage that it has done to their children, to their community members, et cetera, et cetera. So even in this bastion of hardcore punishment lens and approach to this, and in the middle of a coup, in the middle of a COVID crisis, we're starting to see the embers of a counter movement to move beyond this appalling these appalling approaches. So the only reason I kind of say that is if the community doesn't know, to your point, Elisa, as well, if they don't know or don't have the bandwidth to think about something, then they're not going to react and look to kind of change it. And I think it's the same here. Like if we were to survey the people of Frankston around our project, particularly people who see the impacts of drug use or violence or et cetera, there's not huge amounts of sympathy or empathy to that point. But if you go a step further with the people and continue in a discussion to outline some of the kind of the alternatives and what we're trying to achieve, et cetera, and through our stakeholder steering group, we were able to kind of do that. And all of a sudden you do start to change the discussion and the narrative and the dialogue. But then there's the whole need for mobilisation around communication strategies more generally. How do you kind of knock out, how do you counterbalance the 3AW perspective with the ABC perspective, and how do you and the Fairfax or the Herald Sun and have these discussions at a broader level of community. And I think back to one of the things that Daniel was saying before, as soon as someone gets into the justice system in Northern Europe, they're already trying to work out how to get them out. And I think if our underlying principle of any kind of interaction with the justice system, particularly if it's non-violent offending, was that we are trying to keep you out, and everyone knew that, I think then that lays an environment, creates an environment where alternatives and diversion can be taken a lot further. And I think that's the point around diversion. Like diversion's been around for a while, but the expanded definition of it and its expanded opportunities for application haven't been tested perhaps as fully as they could be. And so like we've argued previously for the definition of harm reduction to be expanded, the definition of diversion and its opportunities to be expanded as well.
Yeah, thanks. So any questions from the floor, from the folk in the room?
Just a reminder, I think, Christine, we answered this question before. Nick Thomson answered it before, but the report that you have, Nick, we will upload to the Yarra Drug Health Forum website, to the page which is for today's event. And if you're subscribed to our newsletter, I've dropped that into the chat section as well. There will be an update sent with when all of that is available. So slides from Daniel as well will be up there, and the full video of today's event. And I just wanted to I'm actually trying to find a TikTok that I saw that I wanted to show you as well, but I can't find it right now. But on TikTok, there's a couple of accounts that are doing something that's a very voyeuristic. We see it on other social media. It's sort of an example of a broader attitude on social media. And it's people filming people who are clearly substance affected in public. There's a few locations around Melbourne and Geelong that seem to be hot spots, and people are treated as content fodder, especially on some of these channels. But somebody said, and this is the part that sort of intrigued me, that they'll never learn unless they see how embarrassing they're acting. And I thought, well, in some ways, this person is trying to express that we need that's a sort of justice in itself, that the people need to learn how embarrassing they're being in public by having themselves recorded and played back. But I really think that goes like if you look in the comment section of these things, it just turns into a voyeuristic kind of display of look at the silly druggy people, let's have a laugh. But I think that attitude of thinking that this is somehow going to help them is pretty pervasive, and it's part of that kind of idea that we need to punish these people, we need to put them on display, we need to put them in the gallows in the public square and throw apples at them. I mean, what how do we get out of this attitude? It seems really pervasive, and I think it's one of the reasons that that in Australia it can be very difficult to have these discussions, because people see that kind of that kind of act in and of itself as a act of justice, even though we're potentially making that person's experience of life generally much worse, which will probably lead to more substance use, substance dependence, ongoing mental health problems, and so on and so forth. The question was, what can we do to sort of push back against this? But I don't know if there's much else beyond just trying to have a conversation with somebody. And generally, I've found that one in 100.
I think Elisa wants to jump in there.
Yeah, I can try, Nick, but also I think the other Nick wanted to attempt as well. I think I was quiet for so long because I'm just, I know that it exists, and every time I hear it, I'm not on TikTok or social media for that matter, but I'm appalled every single time. And I wonder about, what can we do? I think there's a complacency as well, and an acceptance through that complacency that that's the way that the Herald Sun is going to dictate to the broader populace, and so we speak our outrage amongst each other, and we don't necessarily work out a way to get through. Sorry about the background noise. Get through to other people, to the broader populace in the same way as Mr. Murdoch has so effectively done. And as much as I abhor the strategies that he's used, I wonder about what learnings we can take from accessing people and tapping into their hearts and minds, rather than in the same way as somebody like Mr. Murdoch taps into their fear and vulnerability. I don't know what that looks like, though, I'm afraid.
No. Any other quick comments, Nick or Daniel?
Just to pick up on Daniel's point around and some of the broader points here, creating environments where drug use and alcohol use and the way it's gone about is done in a way that is either legal and or sensible, and kind of normalised, as opposed to kind of erratic, off the edge kind of stuff. So to Daniel's point around legal instruments and enabling environments, policy environments around drug policy, and obviously, drug policy reform, et cetera, these are really important parts of the puzzle. But without the equal implementation of how that plays out in the diversion space, then it will kind of be left where we are. But yeah, I don't look at those kind of things on TikTok, Nick, because I find them ridiculous. But I completely agree with you anyway.
Daniel, just the last word, Daniel, before we close.
Look, I'd agree with the comments that Lisa and Nick have made. I think there are really active, there are areas that you can be active in that I'm not on TikTok either, so I can't really comment as an expert there. But we have a campaign, I'm just giving it a plug, Worth a Second Chance.
Yep.
It's a campaign to raise the age of criminal responsibility.
Yep.
It is worth lobbying members of Parliament in relation to what we know is effective in this area. Programs like, the one next talking to PACE. I mean, we need to build the broader environment, the authorising environment for this sort of work to get up and running.
Look, I think that's a very good way to end today. I'd like to thank everybody here for their contribution, Nick and Elisa and Daniel. And in a closing note, this is the beginning of a conversation, and I'd like to apologise personally. We have a very non-diverse group of people speaking today, excellent as they are. We're going to pursue this issue in other ways, and we will be inviting members from diverse communities and the Aboriginal community to be commenting on, because it would have been great to have someone in NAIDOC Week talk to these issues knowing the data that we know. But this has been a fantastic contribution the three of you have made. And not just that, but you're fantastic people in the way you contribute to community. And we're all the better for people like you in our lives and in our society. So thank you very, very much. And for all those in the audience, I wish you a great day and look forward to seeing you soon. So thank you. Farewell.
Thanks, Peter.
Bye-bye.
Thank you.
Thanks, everyone.